And welcome to our August meeting of the ICODR member group. I am very, very excited to be here with all of you. I hope you're having a wonderful summer. And I'm delighted to have our guests here today from Arbitrus. We've got Kimo and Kenny, and you guys have been generating so much buzz. Boy, I keep hearing about you on every corner. So everyone is really, really excited to hear about all the great stuff that you're working on. So without any further ado, let me hand it over to the two of you, and you can do some introductions and take it from there.
Yes. Thank you so much, Colin. So my name is Kimo Gandall. I'm CEO of Fortuna Arbitration. Effectively, what we do is automate the dispute resolution process. And so a lot of our best use cases are kind of for those, what I call relatively low value cases that are high frequency. And so we see that as opposed to, your complex commercial litigation cases where you have an attorney billing like 2,500 hours. Firms are spending millions of dollars just on legal fees. But we also see most of the marketplace is focused on smaller cases. And so we especially see this in the context of health insurance, real estate to some extent, where legal fees are incredibly detrimental to the industry. And so our goal is to help not only lower the fees, but also lower the time it takes to adjudicate. A lot of you could imagine going to court, and it could take not 30 days, maybe 60, 90. It could take years, depending on what the case is, if there's complex habitability questions. And so our goal is to get all of that down at most to 30 days. And if we can do that, we can really revolutionize the way people engage in dispute resolution, which ultimately is to adjudicate people's disputes fairly. And I'm talking about, to be a little revolutionary here, a future in where there's not just no human directly involved in the loop. You might have adjudicators on the background reviewing some of the base facts, preventing hallucinations, but one where people can actually transparently understand how decisions are being made, what factors go into that, and they can adjust their behaviors accordingly. What we're talking about is a complete revolution in access to justice. And so I'm very happy to be here today. Our goal today, I'm going to first show you a quick video, and then we're going to show you if we have any questions, very fast live demo. Does that sound good, Colin?
Perfect. Thank you, my friend.
Awesome. All right, let's start on, I think we have a very fun, short hype video to give all of you the concept of what we're doing.
So is there audio, Kimo? Because we can't hear the audio.
Kimo.
There should be audio. Is my audio not working?
I think when you click share, there's a checkbox that says share audio as well. So just make sure that's checked.
Oh, here we go. Optimize for video sharing, yes. Share sound, it says yes.
Okay, let's try it again.
Let's see. Yep, says share sound is working good. Oh, permission.
The process. You have a dispute, use AI arbitration.
Can you hear it now?
Simply submit arguments. Let AI guide you through the process and upload to our secure portal. Avoid litigation. Resolve disputes in days, not years. Arbitrus. No lawyers, just process.
All right. And so the basic idea is simple, right? You just upload to the main portal. We have a back-end AI system. We actually have a couple papers if your viewers want to go read them on how that system transparently works, adjudicate the issue, and then issue a final decision. Yes, I love it. No lawyers, just process. That's what people want, right? People don't want to have to be engaged in these deep conversations on legal theory, and which ends up being high legal fees. They just want a good, fair result. And so what I'm going to show you right now, we can do a little short demo here. A very simple dispute. It's going to be between a landlord and a tenant over rent. Now, for some context, for you California realtors out there, in California, you cannot embed an arbitration provision in a lease agreement. And so that provision always has to be separate. And so what that ends up being is you have a separate contract governing the lease. And you can, of course, do this. You can do it in a variety of ways to have sufficient consideration. You can pay the tenant $1. You can have nominal consideration. But at the end of the day, you just have to have a separate agreement governing the lease. And that's just because of how the California Arbitration Act works. Happy to field questions later on federal preemption of the Federal Arbitration Act. This has actually come up in a lot of recent case law relevant to arbitration. But let's just dive into what's interesting and what all of you actually care about, which is the technology. Just give me a quick second. I'm going to go grab my brief. And so again, what I want all of you to be thinking about is you are a landlord and you are engaged. You are trying to with a tenant who has not paid rent. The tenant is claiming he's withholding rent because of a habitability problem, and you want to evict him. Now let me. Share my screen. Got any questions before we go? Oh, Colin, let me give you the SSRN link.
Oh no, I'm posting it. It's just I'll type it in. Don't worry about it. Go do your thing.
Perfect.
I'll post it there in a
Excellent.
sec. Yeah.
Okay. So first thing first, in California, you always have to provide proper notice to both parties. Now, question if you can waive out of that. Our theory with Arbitrus in terms of compliance is to do our best to comply with the native state laws, even if there is federal preemption. And so we're going to try to oblige by all the California regulations for notification for an eviction case the best we can. And so both parties will receive this. Kenny, can you move us to the next? So Kenny's the arbitrator. He, at a set time, would move it to the next step. I'm, of course, expediting this, right? We normally have to provide you 7 days notice. With briefings, there'll be another 7 days. We're just going to run through this real fast for all of you.
Go ahead and try. So the system would usually
Awesome.
progress automatically through these steps, but I'm just going in and manually changing it here so you can see the whole system and how everything works.
Awesome. And so you'll see there's a little complete button, important, because we need to make sure the parties have both of their notifications. And so now we're going to proceed to the briefing stage. And so while this is all happening, both the parties are going to be notified of a pending issue. And even before this, they'll, of course, get an opportunity to see the briefs. But each party has to have an opportunity to see what the other is seeing. So there's actually going to be tiered timelines. So obviously, the plaintiff needs to provide their brief first. And then usually there'll be another 7 days after for the respondent. Again, here we have Arthur on board. Arthur, say hi.
Hello.
Arthur's going to be our respondent. I'm going to play the landlord plaintiff. And Kenny here is going to be the arbitrator. Awesome. And so here I'm just going to name mine plaintiff brief. And it accepts basically everything here. And then we can just submit it. And then we have the opportunity to see. Arthur, tell me when you've uploaded yours. Again, remember, this is going back and forth through usually a 7 to 14 day process.
It has been uploaded.
Awesome. Oh, we have a question. How do you engage the opposition without a subpoena from a court, especially if they don't want to? So great question, Ken. In California, under the California Arbitration Act, if you don't respond, the parties can decide by contract. In our specific case, we do not authorize default judgments. So you just still go through this. It's just the other party wouldn't have a brief submitted and the facts would be construed against them. Because remember, normally if you have, if you're in an actual court, right, you do something like a summary judgment motion or something. and then the facts be construed in favor of the non-moving party. If you, in a normal court, they would just submit a default judgment. Because we don't do that, we just construe the facts in favor of the party who responded. But you're right, there is a lot of work that has to go in with actually serving parties. Part of that work from a liability perspective can be done and appropriated through the contract both parties sign governing the lease. All right, Kenny, are we ready?
Yeah, you can go ahead and proceed.
Arthur.
No, it's uploaded.
Did you? Arthur uploaded?
Yeah, they're
Perfect.
up.
So this is Arthur's brief. You can view it. It's just a Word doc. And so you can view everything here. And happy to send all of this to you after. I'm sure we don't want to divide into everything. And so now, Kenny, let's move to the decision phase.
Yep, it's ready. So
All right.
what happens is after everything is submitted, people get a chance to make motions, basically dispute evidence, things like that, if they would like. And the arbitrator, like the adjudicator who's overseeing this case, can make the decision, like the final decision on whether or not to allow a motion like that to go through. The system will handle most of it automatically, but there's always a human step in there. And then once everything is submitted and both parties are, they accept that, you know, all the evidence submitted is okay for processing, then the arbitrator can basically open it up for a decision. So the decisions are generated usually every night, and then they get released the next morning. And then we tell the parties that their decision has been released. In this case, we're just going to push it through again manually, so that we don't have to wait overnight in this call.
Awesome. So let's push it through, Kenny. And again, happy to field questions while this is coming. Please throw them at me.
Yeah, Kimo, I'm also guessing that people are gonna have a lot of questions at the end of the demo, so we'll have a Q&A session.
Yeah, we'll have a good Q&A. Happy to talk about it. Seems like there's a lot of contextual legal questions. Again, now I have to give my cursory disclaimer. This is not legal advice. However, it is legal research we've conducted in the jurisdiction. And we do provide template contracts on the Arbitrus website for California real estate. We have a question.
This is a good question. What happens here is this is all done by AI. So we have, and this is in our paper, we have a series of classifier models based on real US case law and prior decisions from the real world. And we take all of that data, process it, and then create these models, which basically make decisions that are based on all of the same US case law used in real decisions. And it'll make a decision on whatever it's provided. And then we use other models to write basically all the reasoning for that decision out. And then that's uploaded into the portal. The only thing that a human does is they read it at the very end, basically as a quality check to make sure that all the arguments were addressed, everything was covered, and there's no like false citations or anything like that that could cause an issue. And then once they approve that it's good, they'll release it to the parties. So Kimo should be good if you want to try.
Yep, awesome. And here's your full opinion.
Wow.
And so, and I'm sure a lot of you are wondering, like, how do they make sure this isn't hallucinating? You've seen all the bad ChatGPT cases. Happy to field questions on that. As Kenny went over some of the technical processes for the actual decision making. I mean, there is an interesting academic conversation. Highly recommend you follow our YouTube channel. We're going to be posting some of those conversations on the distinction between rationale and decision making. But basically, we have a complex series of algorithms that help us solve a lot of the hallucination problems. We call it Raw.ai, where there's kind of this iterative backend process. We're also working with the federal government on some of this stuff. which is going to be slightly different from a statutory binding scheme. That's where all of this comes down to. We had some more comments.
Yes, let me answer a couple questions here. So we have, are these decisions meant to guide the arbitrator? So the arbitrator does have kind of the final say on every single case. So you could look at it that way. But in most cases, the arbitrator is just there to make sure the AI didn't make any mistakes and then approve its decision. So you can kind of see it either way. The human does get the final call, but they typically are taking the judgment made by the AI. And then we have what happens to the data uploaded by the parties. So we do have to retain it to make sure that we can go back and pull up anything, in the future that we might need to, if there's some kind of forced appeal or something. So all of your cases are still accessible in the portal for up to a year after the decision is rendered. And then after that, we take all of it off of our live databases and move it into cold storage, which is basically just a disconnected area where it's kind of more secure and much more difficult to access. So that's how we're doing that.
Sure, kind of a data warehouse.
That's exactly right.
Okay, well, so this is really impressive. Do you have more things that you want to show off in terms of?
No, so this is the basic system we wanted to show for now. If you go to our YouTube channel, highly recommend it. We dive into complex questions with discovery. We actually have other steps here like hearings, but the goal here is to make it simple for parties. You don't need complex discovery procedures for your landlord-tenant disputes, nor do you want them. The goal here is to provide productivity. Yes, Peter.
Hi, could you speak a little bit more about hallucinations and how you catch them? It sounds like you have both human beings and technology involved in catching human hallucinations. Could you please dive into that a little bit?
Yeah, I'll let Kenny dive into the tech, and then I'll talk about the human side.
Sure. So for the technology, as far as AI goes, we're always training new models, and then we're always using state-of-the-art models from basically major companies for other parts where we don't make the models ourselves. And that helps a lot because as technology has progressed over the last few years, hallucinations have gone down dramatically. So you might have seen GPT-5 was released yesterday. We're not using that model, and I don't plan to right now, but I'm just using that as an example of kind of where the technology is going. So the biggest advancements on GPT-5 were not so much in its reasoning skill. There were improvements, but they were less marked than previous iterations. The big improvement on GPT-5, if you go read the model card, is that it hallucinates way less. It's much more difficult to jailbreak, and all their safety measures have been stepped up to another level. So all the major players right now are working on increasing hallucination safety, and we're benefiting from all of that as it happens. So that's one thing. And the other thing is the decision itself is made by a classifier or like a classifier model. And those really do not hallucinate in the same way because they don't generate data in exactly the same way. So we don't really have that problem with the decision itself. We just have to review the arguments and reasoning that are used to basically justify the decision, if that makes sense.
Yeah, and Peter, to go off that a little, with the quote human in the loop, we've actually developed an exam called the Fortuna Insight Adjudicator exam. We've submitted it to the federal government under the Centers for Medicare and Medicaid for their independent dispute resolution service. And our goal here is to provide an easy to access checklist for human arbitrators to be able to access the data that's being signed and then sign off on the cases. And so you're talking about a human able to review a case in minutes compared to writing one in days to months. And so how that process works, there's a couple of technical things. I don't know how tech savvy this crowd is, but one of the big revolutions that's been happening with the models that Kenny and I used to have to deal with a lot in the past few years was context window size. Now, what context window size is basically how much data can you directly show the model? And, obviously, that's impossible to do with every case, right? There are millions and millions of cases, so it far exceeds the context window. So the real question is, especially in the past, where the context windows were what, Kenny, like 64,000 tokens maybe? How do we get the very narrow number of cases into that context window? And so there are basically three strategies we took. In the past, we took RAG, RAG is the most traditional, the retrieval augmented generation strategy. And then we just took those cases and directly provided them in the context window. To some extent, RAG will always play a role because there's so much data. That being stated, when you have these defined workflows, like in real estate, like in CMS IDR, like in transactional disputes for logistics supply lines, you can filter the data down sufficiently and place it in a context window that even if you read our paper, we have a system called raw.ai that's iterative. So it'll just keep regenerating until it finds, it makes sure there's no hallucinations, and the classifier models will actually rank that. That system is increasingly not as necessary as the model size improves because we just feed the data directly into it. And so a lot of these kind of background improvements to the technology have made it easier for us to control hallucinations with sophisticated prompting. And then, we also have a human in the loop. That's what we guarantee clients. I don't think it's necessary. We've not seen any data that suggests the humans are better than the bots. In fact, actually, across a wide number of cases, if you show humans 1,000 cases over the course of a day, the bot is actually probably going to outperform them. But we do it because clients want to feel like someone who's legally competent has reviewed the case. And so that's why we do it. It's a psychological pillow, and people still need that, to be honest. Yes, Peter, you hand.
Oh, I'm sorry. I should have taken my hand down. So thank you. That was very helpful.
That's great.
Someone asked, how do you enforce the award?
Oh, great question. So that's kind of a bifurcated question. For equitable remedies, i.e. a writ of possession, you would have to go to the courthouse and then file with the sheriff. Now, it's very different. People are like, well, I have to go to the court anyway. Well, that's very different than trying to have an entire trial on a case. Yes, you have to go file some paperwork, right? California is not a self-remedy state. You can't go in and just drag the tenant out and throw their stuff out. You have to go to the sheriff and file it. For non-equitable remedies, i.e. remedies in law, so that is like money damages, we can issue that directly. And if they don't pay it, what we do is we offer a service to finance enforcement. So we'll take a part of your end remedy, we will give it to a litigation financer who will then go enforce it on your behalf. We cannot make money on that. That's not our role. Our only role is to expedite the enforcement process. And there's a number of sophisticated ways to do money damage enforcement. The most sophisticated industrial way you might see credit card companies do is they will actually hire different firms to enforce that for them. So they'll actually go to a court, they'll get an injunction, they can withhold wages. There's different ways to go about doing that. Now, the goal is to remedy the dispute without really high compensatory damages to either side. But if necessary, those are some of your legal tools in your toolbox. Arbitration is generally enforceable, just like any contract is.
Great. Well, let me throw out a couple questions, and please, if anyone has anything else they'd like to ask. But can I just take a step back here too? I mean, tell me a little bit about your background, Kimo. I mean, you were a computer scientist before you went to Harvard Law School, right?
Well, no. I did computer scientist stuff. I worked at the AI labs at UCI and social science school.
Oh, okay.
And so we actually have several papers we produced long ago. If you want to go way back into the past, I was actually writing papers on international institutions and machine learning. And so we have a UN paper out on that, actually predicting voting patterns using their speeches.
Cool.
And so that's kind of a lot of my background. I've done a lot of stuff in the business world too. It's actually, fun fact for all you realtors out there, I was a real estate agent in California.
Wow.
I'm working for my parents' company. So we've actually road tested it with my parents' company. So this product is live, it's being used. And that's kind of a little bit of my past.
Amazing.
I just graduated Harvard, just took the bar exam in Texas. Look forward to probably eventually doing the California one too.
Fantastic. Kenny, please.
Yeah, of course. So my background's actually from the mining industry. I have a bachelor's in mining engineering, and I went to work for an extremely large copper miner with international operations. And I worked in the IT sphere supporting a lot of extremely important applications that ran our operations. So we're talking things that, like, if it goes down, we lose millions of dollars an hour, which is kind of high stress. I moved from that into like an application development side more. So I worked with teams of overseas developers and coordinated with them and frontline workers. What we would do is basically figure out what the operations needed to drive revenue and reduce costs. And then we would basically design an application that suited the needs of the operators, and then get it made and deploy it out into the field, which is a long process. And then I got a master's in computer science, and then Kimo asked me to come help him with this. So I've been in the legal tech field for about 2.5 years now.
Awesome. Yeah, we actually have a fun story on that. We were on a barbecue road trip. We were kind of shooting back and forth and what we were going to do in terms of a paper. And we were like, these models are expensive. Let's make a company instead of just open sourcing it because we need to build something. So yeah, there was also a question in the chat about how do you ensure informed consent of parties and or due process. So I think what this person is talking about is a legal doctrine, both in California and other jurisdictions, known as unconscionability. Usually the due process side of unconscionability is procedural unconscionability. And that is actually the heart of the concern of including an arbitration clause in a lease. And that's the reason why we have a separate contract that we require parties to sign, and for there to be separate consideration behind it that solves some of the procedural unconscionability questions, because now it's not like a hidden phrase in the contract, right? Like, it's at the top of the contract, it says Arbitrus, and then it talks about arbitration. It's a one-page document that the parties have to separately sign and render consideration for. Due process, if you mean like within Arbitrus itself, so we actually have a whole rule book. If you go to the Arbitrus website, I didn't show it because, it's boring. You don't want to look through the 50 pages of due process rules. We expedite that on the front end. You just see the notice provision there. It changes dependent on your industry. So if you go read our rules, we have we call them Rule 10 exceptions. We have different due process requirements for healthcare. We have different due process requirements for certain jurisdictions. Like we have Wisconsin real estate. That has a different due process standard. And so we define the process to the workflow, acknowledging that due process, people don't acknowledge this often, but I think is increasingly seen. Due process is very, very, very expensive, especially to people who don't have lawyers, because it requires you to make all these different pleading standards. Like, come on, if you go to a pro se litigant and ask them about Iqbal pleading standards, they're going to have no idea what you mean, even though it's one of the fundamental concepts to filing a legal claim. And so we try to expedite that process and make it as simple as possible. The goal of this is to be charitable to both parties while expediting the time frame. And so, even in some cases, Arbitrus might even give you longer to file than a court might, especially on a response brief. And we shorten that timeline still on our end by being more efficient. We have a question, another hand up.
I think that was Colum who just put that. Do you have another one?
Yeah, I do actually.
Yeah,
I'm an arbitrator, and I can see the use of mediator arbitrator. I can see the real use of this in, say, supply chain or contractor type thing. I just finished designing a MedArb project for procurement within our federal government. And, one of the things we were really interested in is the fairness of it. And how do you do that? Because I'm in Ontario, and so each province has said slightly different arbitration act. But the real problem that's developed in the last few years has been around the process, because as you know, you're either going to have no appeal or very restricted appeal. So everybody attacks the process. Now this, if it's a small money amount, probably not. But I'm really curious, why would a tenant agree to use this system? I can see why a landlord would, but why would I'm assuming we're talking about commercial and residential, but let's talk residential tenancy, okay? Because again, not knowing the situation in California and Ontario, we have a landlord and tenant board, which of course, almost like the courts, is really bogged down. We're talking year plus kind of stuff, during which time it's very common for a tenant to not pay. So it really gets to be a problem. Okay, so there is a definite problem that this could address. But why as a tenant would I sign an arbitration agreement to use this if there's another mechanism that I could use? I'm just curious
especially
what
if
you
that
see as
mechanism.
plus.
No, absolutely. And so the blunt economic reality is money now is better than money later. And so one of the assumptions I go into this, and we've seen this in effect with the landlords we work with in California, most tenants, I'm not saying all, but most tenants come in charitably, right? Most tenants are not coming into a property assuming they're never going to pay rent or they're going to be hostile tenants, right? Effectively squatting on the property because municipal laws and regulations allow them to. They normally get pushed into that situation by external circumstances. And so the cool thing is we're able to show them real value immediately. Oftentimes the landlords will discount part of the rent for the first month, for example, on us, conditional on signing the Arbitrus agreement. Now they don't have to sign the Arbitrus agreement, but then they're not going to get that discount. And so that separate rendered consideration is real money in the hands of consumers. And think about it, the only real cost being absorbed by the landlord is reducing the procedural cost. The tenant himself is never going to realize that procedural savings without signing the Arbitrus agreement, unless he intends to be a hostile tenant. And because most of them don't, and because I don't think we should encourage society to have hostile tenants, we're providing real value to tenants that are effectively subsidizing hostile tenants. And so in a lot of ways, if the tenants are charitable, this is just saving them money. Does that answer your question, Cole? We can get into a very fun economic, psychological conversation.
It does and it doesn't, like everything else, right? I mean, the cases we always see, and we see for mediators arbitrators, are the case where people aren't necessarily jumping for a small discount. They may want to spin it off for a long period of time. But I'm just curious about it because I think arbitrators have two duties. One is to produce an enforceable award. And the second one is not to start another fight over the award. And so I'm kind of, I think we focus on one and not looking at number two, which I think is almost as important, especially if it's an attack on the process. I do a lot of med-arb, which is kind of controversial. And a lot of people, but I do a lot of it and I train it. And, I'm always really cautious in terms of protecting the process. And that's why I'm just curious. I mean, I think this is really pretty cool stuff. But I just wonder why. And the other thing I could see as a potential problem is, if loads of landlords decide to use it, but not too many tenants come to bring a case to you, there may be an issue around perceived bias, which, if you've got a black box system, nobody can tell you how it works. So, and your article, by the way, that Colin referenced is really interesting. I skimmed it. It's very well put together. So that's just my comments, because we usually see negative stuff, right?
Yeah.
So
no, of course that's the nature, right? We only see the worst. That's just inherent to being an arbitrator, right? Because if it's even a little bad, they're usually not going to want to file with you, especially because it's transparently, it's not free with Arbitrus. In fact, we try to discourage parties from filing if they can resolve their dispute in another way. And that is embodied in the prices we charge. So, yes.
Yeah, as I said, I can really see its use in, supply disputes where people have
we're working
high
there
volume
too.
Want it done like this. Yeah, really good. Thank you.
And we have a question from Daniel and Mevez, but let me inject here my own question to build on what Colin just asked. So, I mean, obviously the award you generated is very impressive. It's very thorough, but is there any other, I think of this as like European style documents only arbitration, where both parties upload their brief, everything needs to be in there. I don't know do you have an opportunity for the parties to engage in a negotiation process or communicate back and forth? Can that be integrated into the model when it makes its decision? Is there an opportunity for, testimony or evidence or things like that? Or, is that where
I'm going to bifurcate this answer for you, Colin.
Please.
So on the second one, it's easy. Yes, you can upload them in the briefing section, or if the discovery section is enabled, the discovery section. So yes, and we use classifier models to basically classify them. How machine learning scientists have been doing this for a while now is they basically have a set of like honest, dishonest data, and they're able to build models based off that. That's really how humans react, right? You've seen a bunch of testimony, you've discerned who's honest and who's not honest. In fact, your subset of experiential data might even be less accurate than the machine because it's seen so much more. And so that's pretty simple. The first one is actually, I mean, this is what was brought up in the prior question. MedArb is very controversial. And the reason it's controversial, for anyone who's not heard of MedArb, the difference between MedArb and mediation and arbitration, they're different, is it combines them. And so in MedArb, the mediator has knowledge passed to the arbitrator. What that often looks like is the mediator is the arbitrator, especially in the American context. And the reason that's controversial is in mediation, both parties sometimes give information they might not in an arbitration setting. And so the criticism of MedArb is that sometimes parties during a mediation might not pass additional information along, or they might be more hostile, or they might just be more, by the nature of that guy turning into the arbitrator, if things go badly, be more hostile than they might otherwise. We've contemplated that. Now, the cool thing with AI is if we did build out a mediation component, it would truly be separate. Yes, the same company might be providing the MedArb service, but it wouldn't be like the same AI model. Like the model literally would not have access to the data. And that might be easier psychologically to internalize. There's not been any studies done on that yet. And Kenny and I personally are suspicious of AI in the mediation capacity. Because the whole point of mediation is kind of have that human touch, right? It's to be there and get the parties to compromise and be able to show some sort of human expression. That might be a little harder with artificial intelligence. And I think a lot of the studies are beginning to demonstrate that. That being said, we do encourage settlements. Our rules permit what we call withdrawals. But again, once you get to the arbitration component, we are not involved in those settlement negotiations. The parties can decide to and then withdraw the case or not. But great question on kind of incorporating mediation. This is actually, I took several classes on this at the Harvard Law School. It creates a lot of interesting ethical dilemmas, some efficient, some not. eBay actually had a MedArb system built into it internally. That system is a little different, right? Because the arbitration is not truly binding. It's just if you want to use their platform or not. And the way they incentivize it is kind of what we would do if we built a mediation system, which is we're not actually acting as a mediator. We're just kind of telling the parties they have a certain window of time to compromise. And if they can't, go straight to arbitration.
Great, thanks. Let's
Can you
go
tell
to
us what types
Daniel's question.
Yeah.
I think the first question is, could you clarify what data is in the data set from which your models learn?
Yeah,
sure. So there's
that's pretty easy. All of the data we use is public, open access legal data. Now, not all of it is easy to get. You're probably aware that federal and state governments don't always make all case decisions publicly available. They don't always make all applicable statutes and regulations publicly available. So we have quite a complicated and sophisticated process of gathering all that information. And then once we gather all of it, we process it into a variety of different features. So we look at kind of the arguments and legal standings in everything that we gather and how they all basically are connected. And we make these graphs essentially between them. And then we're able to train on all of the arguments individually and how they pertain to different fields. So we actually also create different models based on different types of disputes, which is another question that was asked. So yes, we do handle different types of disputes. We just make different models for each one. So it's kind of customized. So when you receive a decision from Arbitrus, it's based on applicable law to the specific dispute that you have without data. Kimo, you're on mute.
Sorry. The next question comes from, my goodness, I'm going to butcher your name. Colin, can you help me out here?
Sure. Mérez Philippe. Is the model you're using applicable to other types of disputes?
Absolutely. What we try to do is tailor it to the workflow. And this was brought up before. The process is so important. So we usually meet with the client. If we have a new workflow, We'll meet with the clients and we'll decide what we want the process to be. And then after we decide the process, we build the model around that. Everything has to be built around the process. Again, that's our whole motto, right? No lawyers, only process.
Yeah.
Great.
Can you tell?
The whole system is very modular, so it doesn't take us like a long time to build out for a new industry or a new type of dispute. We have a whole bunch of different modules we can choose from and then string them all together basically into reusable templates. So we can set up specific templates for an industry. We can set up specific templates for a specific company. There's a whole bunch of things that we can do to customize it if needed.
Yeah,
Great.
our platform can basically adjust to any legal workflow within about a week. Now, client integration is another matter because we got to work it into their contracts and get all the parties onboarded, but the technology itself can very easily adjust.
Great. Next one is from Peter. Can you tell us the types of disputes this will not handle?
Sure. So right now we prefer, it can handle complex commercial litigation technically, but we discourage that right now for a very simple psychological reason. We probably will simply create a separate workflow for complex commercial litigation that involves a human lawyer directly, which is parties when there's a $50 million dispute on the line wants to see some sort of human there. In fact, we've actually received feedback from clients we've done pilots with on experimental or complex commercial litigation cases that they don't like that it gives them an outcome in an hour, right? They just don't feel like it's been contemplated sufficiently. And this is also partially the psychology of a lawyer, because if you lose in an hour, it kind of suggests you suck. And in reality, that's not what it means, right? Anyone with technical proficiency understands AI can just comprehend information very quickly. You might have had been 1% away from winning and you did an amazing job, the best your client could have asked for. You might have been able to influence the model to prevent you from suffering major damages. But again, the psychology of all this suggests that complex commercial litigation for the foreseeable future will remain in the hands of at least a human in the loop. Now, what we might do soon is release a complex commercial litigation platform that just has a lawyer. It'll have a hearing in which a human hears you out, but the AI is still driving all the decision making. So the system and fun fact behind this too, we actually originally rendered awards in an hour. We now take 3 days. And that's not because of any part on our end. It's because we have seen clients much happier getting an award later. People just think they're, especially losers. Because remember, and all the arbitrators here know this, every loser is going to hate you. They're just going to be unhappy. And so really the question is, how can we mitigate that unhappiness? And the way to do that is by showing them there was a fair hearing. And so we spent a lot of time trying to do that. And one of the ways is just don't immediately give them a result. So the system cannot generate a consent award and parties just have to withdraw. Good question on consent awards. Yes, we can. We actually have a motion button you can go into in there, and our rules enumerate a consent award motion. So in our system, we simplify it. We don't want consent award to be another type of motion. We just say that's a summary judgment motion, and both of the parties enter it, and then we will enter it for you.
So I have another question, Kimo, and this builds on what Morinike asked. What about like a non-binding evaluation of a dispute? You know, if two parties come in and they're still in the negotiation process, this is often something that people ask for a mediator statement, where it's like, look, it's not binding, but if you were to decide a fair outcome of this case, what would that look like? Is your platform capable of generating that as well as sort of an advisory element, non-binding element?
Yeah, great question. Actually, we talk about this a lot in the paper. It's actually a very large piece of controversy because normally people don't want arbitrators directly doing that. That's not because of any intrinsic reason to the law or the FAA. I mean, maybe it's a partiality question. Maybe it's partially an ex parte question. We call it ex ante querying. And so the idea is if the AI has already had, through its training set, a predetermined idea, at least through a probability analysis of what's going to happen, why can't we just ask ahead of time and get, be done with all this silly process and then immediately just settle every case? And that kind of is the theory one of our academic advisors, Jack Kefauver, has, that eventually that is what is going to happen. It'll basically be predetermined, and the only reason you would arbitrate is to roll the dice, try to get a different outcome than the one that was kind of, I don't want to call it preordained because that's not really what it is, but was forecasted, might be a more accurate conclusion. We do allow that under our ex ante query rules. Under the FAA, we have to restrict that. So, for example, the parties can bring it. The parties can, even a single party can come under a single contract provision before a dispute is filed and ask about hypotheticals. But what we cannot do is engage in ex parte communication. So what we cannot do is, if a dispute has been filed, we cannot create forecasts at that point. And that's simply because of the pre-existing statutory regime.
I mean, if you play this out, it's interesting. Jack's point is an intriguing one. I think if you have an algorithm that can reliably predict an outcome to an arbitration 98% of the time, well, then why would you even file the arbitration? I mean, before you begin the process, Richard Susskind talks about, do we want to, hire ambulances at the bottom of the cliff, or do you want to build a railing at the top of the cliff? And if you say to people, hey, go to this algorithm, upload your information, it'll tell you your outcome. It's going to be 98% correct. Maybe people even specify in their contracts, if we ever have any disputes, we're just going to have this algorithm decide it. If we trust the neutrality of the algorithm, they don't even need an arbitration award. It's like you just make it binding within the contract. So it's interesting to think about the upstream here as well. We can move
Well, this
up.
is the future of transactional law. I mean, imagine instead of paying your lawyers insane amounts to adjust the periods and semicolons, you're paying them to run a probability analysis on every clause and then running hypotheticals on it. And then before, the entire contract's already been applied to the law before the parties sign. That is, I think, the future we want, because disputes are terrible for every party, even the winners.
Well, I have a million questions here, and I know we're running out of time. I want to make sure anybody has anything they want to ask, because this is really, you guys, your energy is palpable, Kimo, and your passion and your smarts, Kenny. This is exciting. This feels like a peek into the future here. But another thing is, how do you evaluate your models for bias? I mean, can you run test cases through millions of test cases or thousands of test cases and see what it generates? And how are you confident in the overall decision-making power of the platform? You can evaluate on a case-by-case basis, obviously, but I was just wondering, what do you do in that sense to sort of do the? I mean, it's funny. Kenny actually,
biases.
There's a lot of people doing data mining these days, but Kenny literally did mining. He was doing copper mining. I mean, that's a real pathway. So he knows how to mine. But so how do you deal with that issue? Because that's something that I hear a lot of the bar associations are not happy with this. Immediately they go after the bias question. And I just want to know what are you doing to respond to that, kind of proactively?
So we've been kind of engaging in education. I try to, lower the hype a little. Sam Altman posting the Death Star usually isn't the best way to get people to think this is the magical genie in the bottle. It's not a magical genie. It takes an enormous amount of engineering. And we actually submitted a comment to the California judiciary under SP 2501 on the bias question. And just basically summarize it, it should only be as biased as the pre-existing system is. And if you don't like that, you should change the system. It's unreasonable. If the training data is based off humans who are biased, you would expect, likewise, the machine to do the same thing. And kind of having a different standard for AI moves us away from kind of the point of this, which is providing individualized justice. I'll just give the edgy examples. This was what the California judiciary was asking about. We know that Black defendants are disproportionately incarcerated. That is an objective fact, at least in the state of California, Texas, a lot of states. And we were actually, we still are, working on a method of pretrial bail algorithms. California loves its sentencing algorithms, right? It's had these since the 1990s. And the problem with that is the legislature does not want to go into the algorithms and manually change them, right? They don't want the responsibility of that. So instead, they kind of seem to be like, the algorithm's biased, the algorithm's biased. Well, the algorithm is only as biased as the pre-existing laws dictate based on the existential circumstances. And so really the way to control bias here would be to change the law. Now, what you don't want is what I call disordered bias, right? That's bias that is not built into the data set itself or is enhanced by the data set. what I mean by enhanced, and Kenny's criticized this many times because we've had this debate, is if you have synthetic data you're training on that replicates the bias, it's going to focus the bias. So it's going to actually exacerbate it and make it much worse. And so the way we do that, simply put, is we do not use synthetic data at any point. We use only real data, and we have a form of judicial humility. We say we are not better than the judicial system. We are not gods here. We're not policymakers. We are simply here to adjudicate based on the status quo. Activists should change the status quo if it needs to be, but until then, we are here to enforce the law as written. And by the way, the California judiciary agreed with us and struck the bias mitigation procedures in their final promulgated rule.
Okay. Well, I know there's been a lot of change out here in California. I mean, I think there are a lot of very interesting questions about UPL. Yeah. I mean, you're not a law firm.
Yeah,
right?
yeah. And, correct. This is not the practice of law.
Yeah, so very interesting. Other questions, comments?
Questions?
Yeah, I mean, I've got so many that I'll just keep filling the gap unless somebody puts a hand up or says something. But so what are your target markets right now? I mean, you said real estate.
Yeah, so we're working hard in real estate. We're working in a few other sectors as well. I brought it up before: logistics, supply chains, kind of these low value, high frequency cases, and kind of adjusting to workflows there. And so I really like the concept of real estate because it's one where it's not worth it hiring a lawyer or paying the full price of a per hour arbitrator, but it's one in which there's a lot of real harm, and I think we can make a big splash. It is probably what I would consider the only sexy market we're going after. Most people, are not interested about supply chain adjudication. So like we're trying to work with a few major companies. We're hopefully actually going to have a partnership announced out of Massachusetts in the next 2 to 3 weeks on that. So we're doing exactly that.
That's exciting. That's great. You feel like you're getting good traction?
Absolutely.
Yeah, I mean,
we've had cases filed in real estate, actually. So
that's great. That's great. Well, if you think real estate is sexy, I think there's some other case volumes I could inform you about that might be a little bit sexier than real estate, but sexier
we have to
than
balance
supply
it. We don't want to.
Yeah,
certainly. We don't want to be too sexy. I don't want to be involved in major criminal trials.
Absolutely.
And people are going to jail, and we can temper it.
Yeah, and in terms of I think a lot of the public acceptability of these kind of digital arbitration tools are going to come from data. It's going to come from academic analysis. Do you have any partnerships with third-party researchers that can look at your data and maybe take?
We are working on that right now. We're working on a partnership with Catholic University. It's not official, and so we're talking with professors there. Hopefully, we can eventually make that come to fruition.
Excellent. And I know you're in Texas, and Peter obviously is at A&M, not too far away. So, don't forget, A&M's close by. Catholic University.
Peter, let's talk sometime.
Yeah, absolutely.
That sounds great.
I heard the barbecue out there is amazing.
Actually,
make sure to shoot you an email.
Any company founded over barbecue, I have an instant predisposition to thinking it will succeed. So
exactly.
That's just the Texan in me. But yeah, I mean, it's very exciting. How do you think the bar is going to react to this when you guys start to hit scale?
Yeah. I think most of it, a lot of these disputes, like I'll give you a prime example in like insurance claims, right? Most of it's not being handled by lawyers right now. It's not worth it from a monetary perspective. And so I don't think the bar will care too much about.
Why does Zoom always pick the most unflattering freeze moment?
I was going to say.
Yeah, that's rough. But he's out in Yosemite. So, well, Kenny, we're at the last 2 minutes here anyway. Do you have anything you want to say before we wrap? Is Arthur a member of your team as well? I don't mean to ignore you, Arthur. Or did you just join in for the demo?
Yeah, Arthur helps us with some data analyst tasks. So he uploaded the briefs for the other party there.
Great.
The system, it has to be coordinated between multiple different parties. So it's kind of tough to do a live demo versus other products.
Oh, no, trust me. You got a lot of people that have struggled through doing demos of multi-party processes for decades. So we know the struggle. You guys did a great job today showing it off.
Thank you.
I'm so sorry. The Wi-Fi here just went out.
No worries.
So
no worries,
back
Kimo.
my phone.
We know, but we hear you. We hear you. So why don't you wrap us up? We only have a couple
Earnings
minutes
per
left.
partner going to go up. Yep. So, if any of you are interested in having fast, fair, and efficient adjudication, email us. Peter, I'm going to be coming to meet with you at AMM. And I look forward to talking with all of you.
Well, we'd love to have you at any of our upcoming gatherings. We have ADR Cyber Week, which is happening in the fall, an online conference. And then I think next spring, the ODR Forum and Future DR is going to be in Boston. So hopefully you'll be able to join us in person. We can share a glass of wine and talk about our lessons learned and all the things you guys are doing. But thank you for sharing this amazing product. Thank you for all the work that you're doing, spreading the word. I do feel, the saying in Silicon Valley is the future is already here. It's just not evenly distributed. And I see a presentation like this and I think, okay, well, guess what? Here it comes. In 10 years, we'll look back on this and say, well, of course it was going to happen. But it takes a lot of hard work from a lot of smart people. And we appreciate you guys sharing your great progress today. And please keep in touch and become part of ICODR. We'd love to have you as part of the organization as well. So
please, yes.
Okay. Any last comments before we release everyone to the weekend? All right.
Thank you, everyone.
Thank you, Kimo. Thank you, Kenny. Thank you, Arthur.
Everybody.
All right. Take care. We'll see you next month.
Bye.